Benjamin Ama Efle, a legal counsel to Elder Ugochukwu Uchenwa, the applicant in this matter.
Can you let us know what transpired in court?
Yes, today is a day of judgment. We filed action requesting for a tripartite fundamental rights of the applicant and the entire members of the Seventh-day Adventist Church, which are rights of freedom of conscience, right to participate in the governmental affairs of the applicant and all the members of the Seventh-day Adventist Church and all the people who profess their religion on the Sabbath day in accordance with the scripture, and also the right to go to school. Today, we are thanking the judge who has been so industrious in considering our judgment and has given us a partial victory. Today, the Federal High Court has agreed with us that the applicant has a local standard, that is a place of standing in law to bring this action. That is a victory. Victory number 2 we scored today is that the court agreed with the applicant and the members of the Seventh-day Adventist Church that there is a cause of action. In other words, this action today is not frivolous. Number 3, the court also agreed with us today that there was a breach, but however noted that this is a permissible breach. Most importantly, the court, which is on record, has agreed with us today that Saturday is a work-free day. Saturday is a work-free day. Court has ruled that today. However, the court did not consider the provision of Section 2, Sub 3 of the Public Holiday Act. We define public holiday to include a work-free day. So it is a case law that provides that Saturday is a work-free day. And that case law has been supplemented and corroborated by the provision of a statutory law under Section 2, Sub 3 of the Public Holiday Act, which was not considered. Maybe if my Lord had considered that, he would have agreed with us that Saturday as a work-free day should also be a public holiday. A public holiday is defined in Section 4 as that day that you must treat like a Sunday. Those things that nobody will tell you to do on Sunday, you should not do it as a public holiday. And the court has agreed with us today that Saturday is a public holiday. In other words, everything that should not be done on Sunday should not be done on a public holiday. However, the court disagreed with us on the basis that the members of the Seventh-day Adventist Church are minor persons. And of course, that is the only thing. It's also the legal basis. It's a factual issue that we are minor. That means when we grow, we will come back and they grant us this right. And however, the issue did not say that the Fundamental Human Rights Enforcement Procedure in Chapter 4 of our Constitution and the African Charter of Human Rights did not say that it is a right of the majority. It said it is a right of people. And whether it is minor or not, as far as we are people, we owe the right for our right to be what? Considered. It did say the fundamental majority right is the fundamental human right. And it is not a an African Charter on majority. It's an African Charter on the people, whether they are minor or not. So we are thanking God today and thanking the court for hearing us and agreeing with us in 5 instances. Let me reiterate. They agree with us that the applicant has a local standard, that the applicant has a cause of action, that there is indeed a breach, and that Saturday is a work-free day. So I have told the court today that we have started today in this court, but we are not going to end here today. We thank God this is not the final court that has the jurisdiction. We are going to escalate it to the higher judicial authorities where we think that we are going to get justice. Thank you very much.